Good afternoon, everybody. This is an interesting case I want to tell you about regarding seller financing. Seller financing takes a lot of different formats. Sometimes it's a second mortgage, a promissory note, subject to financing, land contracts, all different kind of things. But this particular case is in the Indiana Court of Appeals, and it came back because we're trying to figure out when a cause of action accrues on a promissory note. So in this case, a seller sold a piece of land and a mobile home park for some cash money plus a promissory note due from the buyer, right? And what happened was that payments were made for a long period of time, but then they stopped, and the seller never executed on the acceleration of that promissory note for like 8 years. And so it went to trial. Actually, there was a summary judgment on the case, and the trial court granted summary judgment and said, hey, the statute of limitations doesn't begin until the end of the contract period. So even though there hadn't been payments for like 8 years, in less than that time was when the contract term ended. So it was like ending in 2013. Thereafter is when the lawsuit was filed. And so the trial court was looking at when the whole contract payment term was due and said at the end of that, that's when you have the right to file your lawsuit. The Court of Appeals disagreed with that and said, no, you cannot wait on your laurels. You can't wait for 8 years and then say, gosh, now I'm going to accelerate my note at the end of it. I'm going to exercise my permissive right to accelerate at the very end and use that as your basis for your statute of limitations. So contract law, 6-year statute of limitations. The Court of Appeals then, summarizing, said, no, you cannot wait. It's per se unreasonable to wait that long. You have to look at when the actual default occurred. In this case, it was back in 2008. So that's when the statute of limitations runs, 2008 for up to 6 years. They waited over that. They waited over 8 years to file suit. The court said, no, that's not right. So number one, the default date is the date to decide when your statute of limitations runs. That's the most important thing. Second of all, this is one of these deals where somebody signed on behalf of an entity, and the court on the trial court level said that person has to pay the judgment amount. It was over $100,000. And on the Court of Appeals, on its decision, reversed on that as well and said, no, the judgment is only against the entity, not the individual who signed on behalf of the entity. So very important, two key issues there. Who signs and when does your statute of limitations begin to run? It's on the default date, and it was the entity only. So two very key parts to that case. I'll post the case is Stroud, James Stroud and Heartland Homestead LLC and Heartland Land Trust versus Thomas Stone, 18A CC 1722. It's not for publication, so you can't use it as precedent, but it is giving us some good, important information about how to interpret our contracts and how to enforce them. So seller financing, live and learn every day. Thanks, guys.